we're back. Hey everybody, how's it going? My name is Patrick Tan, General Counsel for ChatArgos, the blockchain analytics firm made famous for outing BUSD's $1.4 billion under collateralization. I know this always gets Jonathan. I'm with my CEO and Chief Data Scientist, Jonathan Reiter. I know you guys. Thank you for watching. All the feedback's been really encouraging. We love doing these shows anyway, but it's nice to know that more of you guys are watching, and I really appreciate that. Thanks for all those likes. Thanks for all the subscribes. Thanks for watching the videos. We hope you enjoy them as much as we enjoy making them. But this week's an interesting week. We have the judgment here from the XRP stuff. We're going to talk about that, about the Ripple case. I'll give you a little bit of my quasi-legal opinion on that. John will have some feedback as well. We're going to talk about Ripple this week. We're going to talk a little bit about Mashinsky, got arrested. What can you do, right?
Yeah.
And then we will also talk a little bit about Coinbase and the DCG stuff.
Yeah.
So quite a bit of ground to cover. We just want to jump straight into it. Let's go straight into. Now it's only what 34 pages. 34 pages this Ripple thing was. This Ripple judgment was. Obviously, you can interpret this decision in a variety of ways. The crypto has responded. Bitcoin jumped. Obviously, Ripple went up like 70%. It's just and. A lot of people are seeing this decision as like, oh, okay, Ripple's not security. None of them are securities and stuff like that. I manage those expectations. I think we need a...
Yeah, some of that coverage is completely
Correct. So
it's a partial...
Yeah, it's it's not satisfactory on either sides, but I think it's more important to deal into things. So we've read it many times, so that you don't have to, and we'll get into things. We even highlighted all the good bits, so we'll show that to you. We'll show you all the good bits that we've highlighted. And then so let's just jump straight into the Ripple stuff. What did you think of this decision? A lot of people are asking us.
I mean, everyone's unhappy, which usually means it's a good decision.
Correct.
There's a bit for everybody to like and dislike. There's an interesting split here between transactions with funds and whatever, the institutional sales,
stuff,
and then people just selling collections of tokens they already had, not to raise money for the business, but to raise money for themselves, just to take profit, such as it is. And that some distinctions were drawn there that are maybe novel, maybe not, a little bit different than the way people normally think about things. Definitely the judgment did not say XRP tokens are not securities.
No.
In fact, it explicitly said in some cases the transactions were unregistered sales of securities.
Yep.
And they will likely be fined probably a lot of money for that.
Yes.
But there are other ways in which the tokens can be transacted that at least this judge says are not securities transactions. It's a bit of a weird one. I mean, I because generally speaking, companies register equity, do an IPO, whatever, listings, sell on exchanges, register as equity. I don't know that regular companies have ever tried to raise money through a securities offering and then sell a bunch of stuff afterwards and say that that's not a security. I don't know if people have tried to do that before. Here, they raised a bunch of money, filled out no forms, and then continued to trade it, filled out no forms. So, okay, that we've come back and said for the last 50 years you could have done this slightly different way of arranging things is interesting and novel, and it is certainly opens up routes to fundraising and company management that would be different, not in a decentralized way, just in a the legal form would be a bit different.
Yeah.
So it is interesting to think about.
Well, okay, let's get on to brass tacks here, right? So, one of the things, and I want to read from the thing itself. Oh, my glasses are over there somewhere. There. Just if you could just reach over to my glasses right now. So, thank you. I'm a little bit on the old side, so I'm gonna have to put these on. Right, so I'm just going to read this bit, which we've highlighted from the judgment here, which basically says, it's on page, where you go, just if you'll bear with me, there you go. Where the court actually refuses to make a decision on the basis of whether or not this...
Oh, yeah. So it's something like, we're not actually deciding whether or not these are securities because we don't have to, right?
Correct. So here we go. So page 18 in the footnote, and footnote number 13, which is okay. So this is in relation to the institutional arrangements being held to be investment contracts and therefore securities for the purposes of the Securities and Futures Act. It says here the court holds only that a common enterprise existed between Ripple and the institutional buyers. The court does not reach the question of whether the common enterprise extends to encompass other XRP holders. Defendants Garlinghouse and Larson the XRP ecosystem or any other entities. Now this is important. It's an important footnote which I think you might miss if you just read the main paragraphs. So this is not, it's off to the races. This is definitely not like this is, and I've seen some reporting which seems to suggest that this is off to the races. It is not. One of the things that surprised me from this decision though was that despite in many parts of his decision where he says, and he reiterates what all the courts have been saying when it comes to Howey, is that look, the courts will look at the substance and not the form. It seems as though in this particular instance that because of a technicality of form, the so-called public trading of XRP was not considered a securities offering. And
so by technicality, you mean the fact that the company wasn't raising any money from this?
It was just other people selling the thing in secondary markets, as well as the programmatic sales. And also, this whole point to that you didn't know who was buying, that's not a requirement. I mean, the knowledge of who is buying these things does not make it. It has no material impact on whether or not these things should be considered securities or not, and whether that's a securities offering. Whether you know at the end, I mean, it's like in an IPO, nobody knows who's buying. You know what I mean? But that's a securities offering.
It is certainly interesting to draw distinctions on the basis of who the buyer and seller are.
Yeah.
If a company sells stock, is that a securities offering? But if the CEO sells their personal holdings, it's not. Those distinctions are weird, and people have not tried to make them before. So, okay, maybe those are correct. I'm not.
We don't know. And I think it's important to point out that this is at the district court, so it's not over yet, not by a long shot. I mean, we've got a few more...
this will keep going for a while.
We've got a few more rungs to climb. If I were the SEC, I would totally appeal this.
Yeah.
Because that distinction that they made is kind of, it flies in what all the other legal precedent and the case law seems to suggest, which is that, look, the courts are supposed to look at the substance, not the form. And by making that very artificial distinction to say that, look, because the company was not actually raising any money from those secondary sales, therefore it's not
it would also seem to map out some pretty easy end runs for regular old securities businesses to get around these disclosure requirements, which are weird. I mean, the labs structure that a lot of crypto uses, where you give the governance tokens, whatever the token is, to some other entity that then operates kind of in parallel running this thing. It would seem that your company could give its equity to some other thing.
Well, not equity. Tokens.
No, whatever. Yeah. It's something representing economic ownership in some sense. And then sell that thing, and that would be those sales.
And that'd be okay. Because that's what this decision kind of says.
Yeah.
Like this decision says that, look, you can avoid the whole registering as a security simply by going through this additional layer that kind of divorces the company from the secondary sales. Now, I mean, but the effect is the same.
Yeah, the U.S. has a history. I mean, particularly you think about election fundraising stuff recently, of allowing people to get around attempted regulatory regimes with this type of structure. I mean, the whole Citizens United thing, the idea that if you set up a thing here, that takes money to give to politicians, this doesn't have to disclose because this is...
Correct.
So that kind of end run is not without precedent in the U.S. legal system, but it does seem like the plain intent of the securities regulations was to restrict this in a way that...
To stop that from happening.
Yeah, and there's no constitutionally protected sort of election contribution type stuff there. So you'd expect the government to, fight back more than they might otherwise.
So I'm not super familiar about those, like, I think they call Form C companies or something like that.
S-Corps?
S-Corps. So, the ones which, you raise the monies and then you give the politicians, but you don't actually have to declare the political donations.
There's a whole bunch of
There's a special name for that, which I cannot remember right now.
PAC, Super PAC,
and the rest of it. So now we know that that's a loophole. They've obviously not... Well, I mean, lawmakers would obviously choose not to close that.
But there are very strong protections for political speech
in
the U.S. that don't apply.
They don't apply in this case. Whereas now, if what you're saying is that, look, we're gonna ChatArgos is not gonna do this, but no, the Cas coin, right? Our friend Cas Pianzi, he's got a Cas coin, right? He wants to do. I mean, he's just joking about it. So let's say now Cas issues a Cas coin for Cas Corp, and the Cas coin actually gets pushed into a foundation or
Cas
trust.
Coin Labs.
Cas Coin Labs, if you like, if you're watching this, Cas, this is for you, and then he sells it out of that. And well, not him, but the labs sells it out of that.
That's right.
That's not considered a securities offering.
It would appear that token could actually represent economic ownership. You could call it equity.
Yeah.
And still, the secondary market trading and sales would be exempt from the regulatory regime. That seems like too easy an end run around the rules.
Yeah.
That if this ruling is upheld, people will push, and the regulators will try to find a way to claw back around it.
Correct.
This doesn't seem like a stable equilibrium, even if it does give you a break for a while.
And let's just put things in perspective.
I mean, no company would want to have to comply with these regulations.
Yeah, absolutely. Because if you can do this, there's no reason to
the part
do
of
things.
Apple that does their IP licensing out of Ireland or wherever their current tax arrangement is based would simply do this to get around other costs.
Absolutely.
As would every large company.
So I don't think this is over yet, not by a long shot.
No.
And bear in mind, if you're the SEC, you don't have a limited legal budget. You have an unlimited legal budget. You can just go after this thing.
Yeah, I mean, it does seem odd. Similarly, I mean, they're not the most politically favored organization at the best of times from their point of view. So the idea that Congress is going to give them additional power, at the same time, I don't think Congress wants to be told this law is no longer applicable. Everybody can get around it. We'll see. I mean, depending on which party is currently in charge, maybe that will vary. It's interesting. It's different.
I can stand to be corrected, but it seems to me that this particular decision at least creates a momentary, what appears to be a glitch in the matrix, some kind of momentary loophole. Yeah,
no, this is certainly a distinction that nobody had ever tried to pursue really before. And
I don't think...
If Howie had only put the ownership of the orange groves into a labs... No, seriously, like, they're saying that would work, and that's kind of absurd on its face.
Yeah, of course.
So, we'll see.
I think that at least on a matter of law, not that I should be able to express one, but at least on a matter of law, this seems inconsistent with the case law, because time and time again they have said, look, the point is investor protection. We're not going to get stuck in the weeds, and this is a case where the court has actually come out to say, oh wait, hang on, we're going to pay attention to some of the weeds, not all of the weeds.
Yeah, okay, so setting that aside, you still have to fund the enterprise, and there was a clear ruling that if you sell stuff to fund your business, and then you go off and you build your business and you give those people returns from that business, that those are securities transactions.
Yeah.
And they are for sure going to get fined heavily for those unregistered securities transactions.
Yeah.
So it's definitely not a get out of jail free card anyway, and that structure, that end run, that loophole does not allow you to do whatever you want for free.
Yeah.
It just reduces maybe and shows you some ways to avoid parts of the burden.
And that bit about speculation and about how, because the guys who were buying, whoever was buying XRP tokens in the secondary markets, that's a function of their speculation, and therefore they had no expectation of profit from the management. That's an artificial separation. Well, think about it. But just wait, hang on. Hear me out. Just think about it for a minute there, right? Like, where would they have heard about XRP? From, like, telepathically?
Sure. Look, this comes up in the equity market all the time where, the shareholders of large companies are not in any meaningful sense part of the enterprise.
No, not at all.
Most people don't even vote their shares and fill out the proxy forms or whatever.
But those are still securities.
Yeah, but they're still securities. So the fact that these people are just speculating on the value of the token and have nothing to do with it, if you own shares in Microsoft, you don't exactly get to make management decisions there.
Yeah.
So where are we going to draw this line?
No, I mean, the point of it is that it doesn't matter if they were part of the common enterprise. What matters is, was there sufficient investor protection?
Yeah.
And I would argue, no.
Yeah, I mean, one way of reading parts of this ruling is these people didn't want protection, they were gambling, they're not entitled to protection if they're gambling.
Oh, well, yeah. I can accept that.
Yeah.
I can accept those bits. But then again, the fact that we go back again to that earlier argument that where it just goes down to form, that I don't know.
Yeah, no,
I don't think that's going to fly at a superior court.
At the same time, the way capital markets are supposed to function, securities issues for companies, whatever, to raise money, are supposed to be financing the business, expanding the business, managing the capital, whatever, position of the business. In this case, the transactions that were ruled to not be involved in securities are people just taking profit on an existing pile of stuff and other people gambling with the stuff that they took profit on. That's not really a normal capital markets activity.
No.
I mean, Apple doesn't just issue more shares for fun. That's not the way these things operate. But if people want to do it for fun, this judge at least seems to think, all right, well, that's fine.
I'll read out that specific paragraph. It's on page 23 of the judgment. It says, because a speculative motive on the part, and in quotes, on the part of the purchaser or seller does not evidence the existence of an investment contract within the meaning of the, in parentheses, Securities Act, close quotations. Now, I think that's fine. I mean, he's not wrong. He's not prima facie. He's not wrong on that. I think that's acceptable. But again, I don't think that's the point.
Well, I mean, this has connections to what the UK is doing, right? The UK is deciding to regulate it as gambling.
Yeah.
And that's kind of saying, You can go after these people for running an unlicensed casino if you want, but you can't go after them for running an unlicensed securities exchange.
Yeah.
Regulated as gambling. I don't think anybody'd have a real problem with that. The issue here, I think, overall is going to be that the decision is that somehow this is an end run around all of the protections. Correct. You want to have it regulated like a casino. No one has a problem with that.
So here's on page 24, sort of like in the middle of the page, second paragraph, it goes, here the record establishes that with respect to programmatic sales, Ripple did not make any promises or offers because Ripple did not know who was buying the XRP and the purchasers did not know who was selling it. Now,
which is the way an anonymous market works. So, there you go. But
I am no securities lawyer, but isn't that exactly how a stock market works?
Yeah, most markets are anonymous on that.
And isn't that a securities exchange?
But they've registered. So what they're saying,
which is why, to me, the judge putting this line in the decision, I think this helps the appeal for the SEC.
Maybe, or a different part of the government go after them for gambling.
So if this is going to be a gambling thing, then that's not good for the market anyway.
No, I think that people don't realize how heavily regulated casinos in most of the world are.
It's going to make it worse.
It's extremely intrusive in different ways.
Yeah.
It's fine. It's not. Those regulatory regimes generally work, but it's not different sorts of problems you're trying to solve there.
So TLDR, all right, TLDR. Let's sort of put a lid on that. Long story short, this decision is not the end. This is not the line in the sand that's been drawn. This is not over by a long shot.
There will be discussions over how much they're getting fined and appeals and
there's going to be a whole lot more going on. So I wouldn't put too much stock into it.
But it's an interesting distinction.
There
may well be some changes in the way people think about it.
I think this thing's headed all the way to the Supreme Court.
Yeah, certainly the government will push if they're trying to take away 90-year-old regulatory structure.
Yeah.
And it's going to go.
This is we haven't heard the last of it. And anyway, so the point that we wanted to make is that maybe read the decision before you decide to go long, but have a look at it. Yeah. Okay, so now the other thing we want to talk about is Coinbase. All right, Coinbase DCG. Okay, we'll talk about DCG first. And they put in the filings to go after Barry.
Yeah, so Gemini made good on their threat to sue DCG and Barry Silbert personally for the Gemini Genesis insolvency debacle.
Yep.
It's a fascinating read because Gemini lays out in pretty great detail the many times that they were lied to, but they also lay out in detail how little concrete information they ever asked for. There's about 5-6 paragraphs in the thing devoted to describing lunch that Cameron Winklevoss had with Barry Silbert at some restaurant in New York, where he convinced him to not pull all of their money. But there was no discussion of requests for records or financial statements and the amount of hard data that was presented is pretty small. Some of that data has problems of its own we can talk about separately. But this is not a situation where these guys pushed really hard to get numbers. So we've talked about this a couple times. There are plenty of incidents in business where people see somebody asking questions or making comments, and that guy's just ass covering, of no value. If you're managing $1 billion of other people's money, it's actually not just ass covering, right? So
you need to do your job.
You need to do that, and it helps decrease fraud. So if I think you've taken all my money and I ask you, what's going on with the business, trust me, bro, it's fine. Like, okay. Clearly, you could lie to me. Trust me, bro, is
It's a crypto thing.
Yeah, well, if I then ask you, can you give me some financials? You could give me real ones. You can make them up, whatever.
Yep.
If I ask you to give me audited financials, a little harder to fake that.
Mm.
If I ask you to give me audited financials, the name and phone number of your auditor, you're going to struggle. Presumably you can pay off an auditor, fake it, whatever. Who was the accounting firm Madoff used? Like you're making it harder and harder by asking the right questions. You're just less likely to get defrauded because if the guy says I'm audited by Ernst & Young, here's the thing, and here's the partner there, you can email and you call them and they confirm that they're your auditor. Like you've now raised the cost of doing that wrong. These guys don't appear to have raised the cost of DCG, Barry Silbert lying to them by making any of the right moves. They seem to have just trusted him with a bunch of money, and they claim to have looked at the books at the very beginning.
Yeah.
There were some news reports on that from 2 years ago. We don't know how in-depth that was, but this filing, it looks like DCG, I'm not going to say lied to them, misrepresented. They certainly presented things that turned out to not be accurate with respect to their solvency. Whether legally that was fraud or not is a separate question.
Well, it's at least misrepresentation.
Probably. But these guys listened to it, believed it, and didn't push back very hard. And that doesn't look good either.
No, I saw that, and
I mean, they asked for their money back. He asked to meet the guy for lunch. Met the guy for lunch and convinced him not to take his money back.
That must have been some lunch.
I mean, but there was no documentation was requested or presented, or because if he presented documentation and he lied, they'd have put that in the filing. This doesn't make any sense.
No, I agree. There's a lot of stuff inside that if nothing else, I mean, if I was Gemini, at least I would want to show that I had done my job.
Yeah.
The due diligence, I was rebuffed with extreme prejudice.
Most of their senior management, not the Winklevoss, but the most of the sort of level below them, are experienced traditional finance executives who would have said,
it is bizarre that,
dude, you have to ask
correct.
for this. Yeah.
So it's bizarre that in this filing, none of that was mentioned.
Yeah.
So that must have been some lunch. Because, I mean, I guess if you get me sauced up, I can't really hold my liquor, so there you go. So I probably forget
and
to
show
ask
you a
a bunch of
4-line
stuff.
balance sheet. I mean, it does not make them look particularly good either.
Yeah, well.
Also, that balance sheet didn't add up correctly. So
okay, that's what we want to say about the DCG stuff. But let's talk a little bit about Coinbase and something that people haven't really considered, which is that your deposits with Coinbase are generally a claim that you have against the company. And we've done some looking up, and there is some precedent for this in the block fee stuff. When they got the fines, half of it was from the states.
Oh, the way all this stuff is going to play out. Yeah,
correct.
Yeah,
so half of those fines came from states, and states can act pretty fast.
Yeah, so the block fee settlement was $100 million.
Yeah.
$50 million was a fine to the federal government, and the other 50 was
split amongst a bunch of states. Yeah, correct.
Yeah.
So one of the things is that Coinbase is registered in California, right?
Well, I think they don't officially have a head office, but
correct.
their address or whatever is in California, I believe, yeah.
And they're in violation of state law right now.
Yeah, so there are a number of cease and desist orders out there that they appear to still be operating in these states.
So they've just completely ignored quite a few cease and desist orders in quite a few states.
It appears to be the case.
If these states want to act, and they can act fast, and the state the state attorney general is not going to care. He's just going to go after you, and they're going to ask for whatever money that they want to ask for not. And those fines, your deposits in Coinbase could potentially be used to discharge.
Yeah, no, a number of these companies look to be likely to end up in a block fee type situation.
Correct.
Where many states come after them, and because as the court stuff piles up, they violate court orders, it'll be easier and easier for those companies to cut them off, get their bank accounts frozen, seize them, whatever amount of money.
Correct.
And that money's coming out before deposits.
Before creditors.
Yeah,
because you'll be an unsecured creditor. You'll be just maybe one step ahead of shareholders.
I believe the SEC has agreed to waive some of their future block fee stuff to help people get a better recovery.
To get their money back. Yeah.
That's kind of a weird precedent because letting people have their money back, they've already suffered substantial losses. Maybe fair enough. But I don't know. Depending on how bad the conduct is, the federal government has no control over all these state district attorneys.
No, they don't.
We'll see. It's going to be very interesting.
And they are in violation of state law. They are. I mean, these things are facts. Cease and desist orders are out there. They are in violation of state law. They have made no effort to stop. And
I don't know whether they made an effort or not, but they haven't stopped anyway.
Well, it doesn't look like they've made any. So, I mean, how many times can you poke the bear before the bear starts to bite your head off?
I mean, this will probably occur with the Gemini folks as well, where there are securities issues, and as we've seen now with quite a few companies, the SEC comes after you for securities problems, and there's also 50 states, 50 or 40, whatever, 45.
50,
but every state doesn't have securities.
Correct.
Almost all.
Yeah.
And those guys will also come after you, fine you, different stuff.
Yeah.
And those are going to come off the top. Whether they'll waive all of them or what's going to happen remains to be seen.
The point that we're trying to make, right, TLDR, is that, look, something you should be aware of, especially if you're still trading on Coinbase.
Yeah, when they're talking about paying fines, the joke is often that, of course, companies get fined and the shareholders pay. But in the case of many of these companies, it's actually the depositors that are going to end up paying. Because for financial services businesses that continue to function, JP Morgan gets fined, JP Morgan shareholders pay. If the company gets shut down, goes insolvent, Gemini Earn type situation, Coinbase is clearly still running, there's block fees insolvent, whatever, there's different places here. If you're in a situation where the legal action takes the company down, it's the creditors who pay, and for almost all crypto businesses, the main creditors are the customers. They don't have a bunch of bonds outstanding. Some of these companies have a small amount of bonds outstanding, but generally their liabilities are dominated by client deposits.
Yeah.
And that's where the money's going to come for the fines, and they know that when they fine them. Right? They knew BlockFree didn't have any money beyond client deposits.
Yep.
Or at least they know that now. Whether they knew that in the beginning is a little bit unclear.
Just be aware.
Yeah.
Okay, so finally, Mashinsky, and then we can wrap up.
Yeah. So Alex Mashinsky of Celsius fame was arrested. I think it's important for people to understand that most of the securities and markets, whatever conduct that's bad, are both civil and criminal problems, right?
Yeah.
So you can be charged civilly or criminally, and the government decides what to do based on how egregious your conduct was. And they have a wide range of things from, slap on the wrist, small fine, banned securities industry, small amount of prison, large amount of prison, whatever.
Death by beheading?
Well, the U.S. doesn't, I don't think they do that for any financial stuff. I don't think there's any beheading anyway. I guess he's going to be charged criminally with some stuff here. That depends on how bad your conduct was. If people go back and look at the famous insider trading cases from the 80s, right, these are people who were enriching themselves, egregious violations of the law. Ivan Boesky, probably most famously. Boesky. People can Google that. I'm sure there's a Wikipedia page for that story. He made like $100 million in a handful of trades, all insider trading, whatever stuff. This is 1985 or something. Those guys were all charged criminally. There, lots of people from that era, Milken and whatnot, because the conduct was so bad and so large and so pervasive. Whether Mashinsky gets charged criminally and the BlockFi people only get civil or whatever, we're going to find out. But that's definitely in play now, and they seem to have concluded at least some of the conduct was bad enough that they're going after people.
It looks like. I mean, This one looks like that looks like they're playing for all the marbles here.
I mean, the money laundering stuff is almost always
criminal, correct.
And then the securities market stuff depends on how bad it was. So,
but
we will see.
We've seen in the past where Raj Rajaratnam.
That was another case of.
Yeah.
I mean, he maintains he didn't do anything wrong, but what he was convicted for, whether he did it or not doesn't really matter, was a lot of insider trading.
Correct.
It was pretty egregious.
Yeah.
Which resulted in him going to prison because it was so egregious.
Correct. Well, he lost some weight, so. Okay. Anyway, on that note, thank you for tuning in. If you guys got any questions, comments, feedback, hit them up in the comment section below. We appreciate when you do it. Otherwise, like and subscribe. Thank you so much for watching. We enjoy making these videos. We hope you enjoy watching them too. And have a great rest of the week. We'll see you again next week. Take care.